My name is Mike Gertner. I'm currently the CEO of Kona Medical. It's a company I founded. I will take a couple minutes to talk about that because it's highly relevant to this intellectual property overview. I'll talk about that in a few minutes. Right now, my background is I'm trained as a surgeon, actually, and that's sort of my connection to ERCAD through James Wall. And then I also am a serial entrepreneur in the Bay Area. I trained at UCSF, and then after UCSF came down to Stanford and worked a bit down here, and then gradually went into the medical device entrepreneurial community. I'm also an engineer by training prior to medical school, and also a patent agent, which is also relevant to this talk. So it's quite interesting to look at some of the history of patents and patent law and how they apply to business. Back in 500 BC Greece, there's this quote. It's an unknown source of the quote, but it comes out as encouragement was held out to all who should discover any refinement in luxury, the profits arising from which were secured to the inventor by a patent for the space of a year. So the actual word of patent comes back from even over 3,000 years ago, and the basic premise of it is still the same, and it's sort of one of the basics of capitalism, right? If you innovate, if you invent with something useful, the law grants you a privilege to share that with other people and also to earn the profits from it. So the origin of the word patent is from Latin. It's to lay open, and it also the basics of a patent are to allow others to enjoy the use of it without fear that it'll be stolen. So you go up to more modern times, 1474 in Venice. The definition is a new and inventive device, once put into practice, had to be communicated to the Republic to obtain the right to prevent others from using them. So a little bit of progression, now part of the kings. In Britain, what's called the statute of monopolies, and this is really the modern patent system can be traced back to this. But the English court developed the requirement that a written description of the invention be submitted, and they protected the patent holder with this description. So what does a patent allow? The Patent Act of 1790, so it's actually written into the Constitution as an amendment in 1790. It's any useful art, manufacture, engine, machine, or device, or any improvement thereon, not before known or used. So actually, we'll go over this, but the three basics of what defines a patent is embodied in this initial Patent Act. It's important to know that a patent is not a right to practice or use the invention, but provides the right to exclude others. It's an important concept because you can actually have a patent and not be able to practice that patent because someone else has a broader patent. If someone, for example, patents a car and they own the car, you don't have the right, and you own, say, a patent on a new type of steering wheel, then you don't have the right to actually practice your patent because someone owns the car. So you have to get permission from the owner of the car patent. Generally, I think there is some convergence across the different countries now in patent law, but there still is a lot of variation from country to country, not only in actually what a patent means or how it's prosecuted, but actually in the importance the country puts on the patent. So, for example, China, India, there's a lot of criticism that even though there's patents there, they're not adhered to, and there's not a great legal system to enforce those patents, and so there's a lot of theft. Now that's improving, but still that's the criticism. In Japan, the criticism is that it can take 5-10 years to get a patent, so by definition, it almost becomes irrelevant at that point if it takes so long to get one. So let's go to some of the fundamentals here. So documentation of an idea. Now, there was a big difference. There still is, but it's going to change between the U.S. and rest of the world. In the rest of the world, it had been that the first person to get to the patent office and actually file the patent sets the date for that patent. So, for example, if I go to the patent office today in Europe, I can set a date for a patent today. Okay. Now, if I'm in the U.S., and this is true until for about another year in the U.S., if I write down on my lab notebook an invention and I sign it, then today is my patent invention day, even if I don't go to the patent office. Now, I think in 2013, in early 2013, but definitely by the late 2013, the U.S. will be on what's called the first to file as well. So everybody will have to go to the patent office to actually declare their invention, and that's going to be a big shift in the thinking here. But even when that changes, the first to file system will still be the invention day date for patents before 2013. So anything, in the last 1, 2, 3 years, today, tomorrow, any of those inventions, the date is the date you put it into your lab notebook. So something to consider at that point.